Good morning, everyone. Welcome to the House Judiciary Committee. I call this meeting to order. Meeting number 3 of the 2024 session. And would our clerk please call the roll?
Representative Banta.
Present.
Representative Blanton. Representative Bratcher.
Here.
Representative Bray. Present. Representative Burke.
Here.
Representative Dietz.
Here.
Representative Doan. Representative Flannery.
Here.
Representative Herron. Representative Kulkarni. Representative Lewis.
Here.
Representative Maddox.
Here.
Representative Mosier. Representative Nemes.
Here.
Representative Petrie. Representative Rawlings.
Here.
Representative Sharp. Representative Stevenson. Representative Wilson.
Here.
Vice Chair Decker.
Present.
Chair Elliott.
I'm here. So we have 4 bills on for consideration this morning. And the first bill we'll hear is House Bill 50. Representative Rawlings, an act relating to the administration of estates and creating an emergency. And Representative Rawlings, if you'd introduce yourself and your guests can introduce themselves. And you also have someone on Zoom, as I understand it. So good morning.
Yes, we do.
Good morning, all.
Thank you, Mr. Chairman. So I'm Steve Rawlings. I serve as the state rep for the 66th District. Mr. Chairman, I'd like to call House Committee Substitute 2.
There's a motion. Is there a second? All those in favor, please say aye. Aye. Those opposed, no. And the sub is adopted. So
Thank you,
may
Mr.
continue.
Chairman.
And if you would explain the difference between the
Okay,
sub and the original bill, however you want to do that.
Okay, we heard this bill early October in the interim, and at that time, one of the things that's part of the bill was eliminating the inheritance tax. So we're going to sunset the inheritance tax. So the committee substitute for a big part is because of that. We've taken that out. And Representative Lockett, who's here today, he's filed House Bill 308, so he's taking care of looking into sunsetting the inheritance tax. And then there were a couple other minor changes that we had from the Land Title Association had some concerns, and an attorney group had some concerns, so we just made a couple other minor changes on that. So a transfer on death deed allows individuals to pass real property, which can be their home or their motor vehicle, to a beneficiary upon their death. This provision would assist elderly citizens of the Commonwealth or individuals with moderate to low household income, since this would provide a simple, cost-effective means of passing our homes and autos to a beneficiary without probate. Because the transfer occurs through the deed itself and is made effective upon death, the transfer is not part of the probate process, and it does not need to be listed in a will. Therefore, using a transfer on death deed can be a cost-effective tool in an estate plan. Kentucky currently allows this type of transfer for funds held in payable on death bank accounts. However, there's no similar means for passing real estate or auto to a beneficiary. 30 states have already enacted the transfer of real property on death provisions. These 30 states include all of Kentucky's surrounding states, save for Tennessee. There was a section added since the interim, Section 23 on page 30. There was a situation with a family who lost a child and had to go through a horrible process with probate as grieving parents. So we feel like this is an important addition to the bill. Section 23, where a minor has assets solely in his or her name, has no living spouse, living descendants, or creditors, and Mandy Jo's law does not apply, House Bill 50 proposes to allow the court to order the administration of the minor's estate to be dispensed with and the assets transferred to the surviving parents of that minor or to a person designated by the surviving parents to receive all or part of the assets without the need to go through probate. So we'd like to go ahead and have Trish McAllister, the attorney from Texas. She's with the state bar. She was instrumental in securing the bill sponsors in the Texas legislature, and she worked for its passage. So, Mr. Chairman, if we could do the Zoom call.
Hi, Mr. Chairman and members. Thank you for giving me the opportunity to talk with you today. My name is Trish McAllister. I'm a Texas attorney and the former executive director of the Texas Access to Justice Commission, which was instrumental in getting the transfer on death deed passed in Texas. In 2014, the Speaker of the House charged the House Judiciary and Civil Jurisprudence Committee with studying issues that hindered the use of wills and access to the probate process in Texas, particularly for low-income individuals. The Texas Access to Justice Commission was invited to report on access to probate by the poor, and afterwards, a state legislator convened a work group of probate attorneys, judges, professors, real estate attorneys, bankers, and access to justice leaders to work on recommendations for improvement. The transfer on death deed arose from their work, and in my role as executive director of the commission, I worked up with state legislators on the passage of the bill. The Texas Access to Justice Commission was interested in the transfer on death deed as an access to justice issue. The family home, a car, money in a bank are usually the only valuable assets a low-income family has. Yet they don't have the funds to get a will, much less probate that will, which at the time was the only mechanism to pass clear title to heirs. For these folks, property passed informally, which often led to cloudy title issues due to multiple family members co-owning the property. When property ownership is unclear, it becomes difficult to sell the property, qualify for tax exemptions, receive property insurance benefits to make needed repairs after a storm, or obtain a loan to make improvements. For example, say a decedent's disabled child is living in the family home and gets behind on property taxes, causing the home to be foreclosed. If title had passed properly, the property tax disability exemption would have applied and no taxes would have been owed, so the disabled child could have continued living in the family home. Consolidating ownership can be so costly and complicated that families abandon the property, which also can lead to blight in communities. A transfer on death deed allows for people to affordably and efficiently pass clean title to real property outside the probate system from one generation to the next. In Texas, many assets, including those with high dollar value, life insurance proceeds, 401k plans, etc., pass outside of probate. The benefits of a transfer on death deed are that it serves as a will substitute for real property, allows a property owner to transfer real property to a named beneficiary upon the owner's death without the need for the beneficiary to go through a probate administration. It must be completed, signed by the owner, and filed at the county clerk's office in the county where the property is located during the owner's lifetime to be effective. It transfers only upon death, so it allows the owner to keep all rights of property ownership during the owner's lifetime. It doesn't give the beneficiary or the beneficiary's creditors any interest or right in the property during the owner's lifetime. It doesn't affect the rights or interests of any secured or unsecured creditors, and it cannot be used to avoid the debts of the owner's estate. So the owner can name one or more beneficiaries, and it's revocable as long as the revocation is in writing and recorded. After the bill was enacted, the commission prepared a transfer on death deed kit with simple forms that could be used by the public to file a transfer on death deed or revoke a transfer on death deed. And since the transfer on death deed was enacted, tens of thousands of people have downloaded the transfer on death deed kit and filed a transfer on death deed. And the transfer on death deed has also become a staple for probate lawyers too, as a tool in their estate planning toolkit. And one thing I was pleased to hear is that the Kentucky bill also includes a vehicle transfer on death. I wish we had done that during the same legislative session that we passed the transfer on death deed, because vehicles are an extremely common asset for low-income families because they need to get to work. And the cost of probate almost always exceeds the value of the vehicle, so people just don't bother to transfer title. Fortunately, we did manage to get one passed in Texas as well the following session, but it certainly would have been a whole lot easier if we'd done it right away. So that concludes my testimony, and I'm happy to answer any questions if anyone has them.
Thank you very much. I'll recognize Mr. McGarvey if you have any comments, and then we'll go to questions after you've had an opportunity to.
Thank you, Chairman Elliott, and my representative Jason Nemus. I come to you not as a lobbyist for any organization, but as one of Kentucky's Uniform Law Commissioners and its legislative liaison for the state of Kentucky. As our prior witness stated and Representative Rawlings stated, what we're talking about is not a new concept at all. If you have a bank account, you've probably designated a payable on death beneficiary. If you have a 401k, you've done that. If you have a securities account, you've designated that. But this is a relatively new act that extends that concept into the arena of real property. Uniform Law Commission offered it to the states in 2009. 19 states have adopted the Uniform Act that you have before you. 11 other states have done something very similar. Missouri's actually had this type of statute since 1989. There have been no problems with its operation there. It is currently before the legislatures of 5 additional states, including Kentucky. So we're looking at something that, for all practical purposes, is almost nationwide. Uniform Real Property Transfer on Death Act is an alternative to expensive estate planning for simple estates. Most people, the major asset they have in their estate is real property, their house in most instances. And this is what this relates to. It allows owners to retain control of their property during their lifetime. Part of this legislation, I read it last night before I came to testify on it, even though I know the Uniform Act fairly well, is a model form, and that's part of the Uniform Act, to create this real property transfer on death deed. But there's also a model form for revocation of a prior transfer. If you decide you want to revoke that and change the person who it's going to transfer to, or not have it transferred to anyone, you're not going to have to go to a lawyer to do it. There's a form right there in the statute. The county clerks will most likely offer it to citizens should they need to use it. It has been proven effective in other states. As I said, the Uniform Act is now in 19 states. It's before the legislature of 5 additional states, and there are 11 states that have done something similar.
Motion on the bill, Mr. Chairman.
There's a motion. Second. Is there any discussion? Seeing none, okay, we do have some discussion. Representative Bratcher, do you have a question?
Just quickly, I'm going through a situation with my wife's relative in Ohio, and they do have a transfer of property, but the guy that died, a nephew of mine, he did not take advantage of that. But man, it would have been so much easier if he'd have done that. And I think our guest from Texas answered this, but of course, if real estate is transferred, then the mortgage is transferred with it, right?
That's correct, subject to all existing liens.
Sure. And then my last question is, what took so long? This just makes perfect sense. So I really appreciate this, Representative Rawlings.
Good, thank you.
Representative Banta.
Did, and this I think is for our Zoom caller, did the clerks or anyone in the office have any problems with these changes? Was it an overburden or a confusing thing for our clerk's office?
No, it really is just a recordation. So somebody comes in and they scan it in. It's not a difficult thing for them to do. No, we had no complaints at all.
They get a recording fee.
Yeah, they do.
Yeah.
Representative Flannery.
Two-part question, please. I was looking at the committee sub, and it indicates that it shall be recorded in the county clerk's office. What if the transfer on death deed is executed, signed by all of the relevant parties, but is not lodged as a matter of public record in the county clerk's office? Would it be void, or because there are situations with just a normal general warranty deed where you'll have a deed that's executed, but it's never recorded?
My gut feel on that is you'd probably end up in probate at that point, but the executed document would be evidence of the intent.
Okay. Thank
Because
you.
the world would not have been put on notice as you anticipate in recording of documents.
Okay. Second question. This is somewhat of a similar concept, joint tenancy with right of survivorship or maybe a life estate. A little bit different, but I'm assuming that there would still be a need for an affidavit of death and descent filed after, obviously, the death occurred to give public notice to any potential parties or anyone doing a title search.
Land title lawyers tend to be pretty finicky, and I expect you're right, Representative.
Okay. So there would still need to be an affidavit of death.
The statute doesn't require it. I would expect that land title lawyers would want to see that.
Okay. Thank you.
Representative Dillon.
In the situation of a property held in joint tenancy, how do these apply there? Could one spouse say that I want to elect a TOD and the other not, and you're going to have split title, or do both of them have to join in?
Both would have to join if the property's titled in joint tenancy. One of the great advantages of this is one of the concepts that's been used to avoid probate on real estate is to add people onto a deed so it automatically transfers to children or whatever. Well, what if you want to change that during the process? This is a much cleaner system for that. Okay. And you've got another issue. If you add people onto the deed, then suddenly that real estate becomes subject to claims of their creditors. This avoids all of that.
Sure. One other question.
Sure, go ahead.
So I could imagine another scenario where a husband owns a piece of property. It's solely in his name. It was acquired during the marriage. It would be marital property. And then he elects to do a TOD and to disinherit the spouse. Is there an opportunity for a spouse to elect? In the case of a will, a spouse could elect against something like that. Is that same opportunity exist in this?
Let me make sure I understand your question correctly. You have property in the name of only husband.
Mm-hmm.
He is still married.
Mm-hmm.
I think wife's going to have to sign that transfer on death deed document because she still has dower rights in the property.
Okay, that and I saw that in the bill, but wasn't sure if that would be. I mean, that may not be caught, right? A clerk may not know that. I guess
Right.
you'd have to write in there that they are married, so that would raise a red flag. But okay, thank you.
Representative Burke.
Thank you, Mr. Chair, and thank you, Mr. Doan. You asked one of the questions I needed to ask, so I appreciate that clarification. I just wanted to thank the sponsor of this bill, Representative Rawlings. You've been excellent to work with, and I appreciate the changes that you've made in the substitute. Particularly, I thank you for meeting my request, but also for incorporating Representative All's request as it relates to the passing of property of minors. So thank you so much.
Yeah.
I'm looking forward to voting on the bill.
Okay, well, thank you so much, Representative Burke. Yes, Representative All had a separate bill about the family that had gone through a really tragic time and had difficulty through the probate process. So there wasn't any need for that. So we've written that out.
Representative Moser. So we have a motion and a second. Would our clerk please call the roll?
Representative Banta.
Yes.
Representative Blanton.
Aye.
Representative Bratcher.
Yes.
Representative Bray.
Yes.
Representative Burke.
Yes.
Representative Decker.
Yes.
Representative Dietz.
Yes.
Representative Doan.
Yes.
Representative Flannery.
Yes.
Representative Herron.
Yes.
Representative Kulkarni.
Yes.
Representative Lewis.
Yes.
Representative Maddox.
Yes.
Representative Mosher.
Yes.
Representative Nemus.
Yes.
Representative Petrie. Representative Rawlings.
Yes.
Representative Sharp.
Aye.
Representative Stevenson. Representative Wilson. Chair Elliott.
With 19 yes votes, no votes, no pass votes, HB 50 is amended by the committee substitute is passed and will be reported with favorable expression. There is a title amendment. Is there a motion to approve? There's a motion. Is there a second? All those in favor, aye. Aye. Those opposed, no. And the title amendment is adopted. So congratulations.
All right. Thank you very much. Thank you to our guests.
Thank you.
Thank you,
for
Mr.
being here.
Chairman, members of the committee.
The next item that we will hear is HB 95, an act relating to theft of services. Representative Lockett. And you may proceed if you'll introduce yourself and the guests for the record.
Thank you, Mr. Chairman. My name is Matt Lockett. I'm the state representative out of the 39th District. I have two guests with me here at the table today. I have Mr. Ian Goff to my left, to my far left, who is a constituent of mine, a local business owner, and also the past president of the Kentucky Rental Association. Also, Mr. John McClelland, who is out of Washington, D.C., flew in last night to this gorgeous weather that we're having here today. He is the Vice President of Government Affairs and the Chief Economist for the
American Rental Association.
American Rental Association. Thank you. I lost my spot.
That's all right.
That's why I need reading glasses when I look at things like this. Simply put, House Bill 95 adds brand new language to Kentucky's theft of service statute to ensure that local prosecutors can pursue a theft of service charge when someone rents equipment and then intentionally keeps it longer than the rental agreement allows and doesn't pay for the additional time the equipment is used. For perspective, there are 121 rental companies operating in Kentucky that also rent approximately $500 million worth of equipment each year. And most of those transactions occur between parties who do respect each other and respect the rental agreement. However, there are instances where someone rents a piece of equipment, holds it for 60 to 90 days past the rental agreement, and then drops it off in the middle of the night. When the rental agency charges the credit card that the person left on file, they find that credit card has been canceled or is no longer valid. One rental company told me that in some instances this happens with a person who might be feeding a drug addiction problem by renting equipment to take on a series of odd jobs just to make a little money on the side and then have someone else return that equipment with no intention to ever pay for the additional time that they used it. I do want to thank the Associated General Contractors, the Kentucky Rental Dealers Association, and the Home Builders Association of Kentucky for working with me and the others on the committee sub that you see before you. So, Mr. Chair, there is a committee sub.
Is there a motion?
Second.
Motion, a second.
I have
All
questions about it, Mr. Chairman.
those- Okay.
Yes, sir.
Well, we can have discussion before we vote on the sub. So you're recognized.
Thank you. I'd like to know what's the difference. When I read it, I like the bill better than the committee sub, and so I want to know what
Yes.
the difference is. Is it commitments that you made? Just tell me the process, and why should we vote for the sub over the bill?
Representative, if I understand your question correctly, one of the purposes of changing some of the language in the sub was to make sure that legitimate contractors who make a legitimate mistake, a lot of these contractors rent lots of different equipment. It may be on several different job sites, and they may have just inadvertently overlooked the fact that a piece of equipment is due back, that their agreement has expired. We didn't want to create a situation like that, and frankly, my members do not want to run around charging their good customers with a misdemeanor or a felony in a case like this. So that's the reason that we changed that language around a little bit to make sure that the inadvertent error on the part of a contractor and their employees did not result in some sort of criminal charge against them.
So the point was just to make sure that the mens rea was present, that it was intentional. I think that would be read into the statute,
Yes.
but it's just to make it explicit.
Yes.
There are no other changes or softening or anything of the bill?
I don't believe so.
No.
Thank you, Mr. Chairman.
Create some leniency,
Yes, sir.
in short. Yeah.
Yes, sir.
Representative Doan.
My question's on the sub, so if we adopt it,
We didn't adopt it yet,
Yeah.
so you can, okay. Representative Herron, do you have a question about the substitute or the bill in general?
Just the bill in general.
Okay, well then we've got a motion and a second, so all those in favor of adopting the sub, aye? Aye. Those opposed, no. And the sub is adopted. So I'll recognize Representative Doan.
I've got a question and a comment, if that's okay.
Yeah, go ahead.
Is the intent of this bill to allow individuals to hold other individuals accountable, or is it strictly for businesses, agencies, and the like?
I believe that it is for the rental company, the rental agency, as it stated, to hold a person accountable who, engages in the activity that's described in the bill.
Okay. Because one of the things that I noticed in the bill was that there's a slight language shift in the sub, and that we stopped talking about the equipment owner, and then in the section 4 we talk about a rental agency. And so it would seem to me, and I could imagine the scenario, in fact I've litigated it, where someone enters into an agreement with a contractor, an individual enters into an agreement with a contractor to agree to purchase equipment that they will then rent to the contractor, and once the job's complete, they will sell that or give that over to them to get a discount on the construction of their home. I would like to see this bill protect that situation as well, and just to change agency and follow that same language from rental agency to owner of the equipment. Thank you.
Representative Herron.
Thank you, Mr. Chair. I just have I guess a question based off of the scenario that you gave us. Could that same situation or the issues of people not returning equipment, could folks be charged with theft by unlawful taking? Like, I know that currently that is a statute. Are the issues that you are seeing, is it been difficult to charge people with theft by unlawful taking? I guess is my question.
Yeah, well, I think, Representative, the difference here, if the person rents the equipment and they abscond with it and it is never returned, then that would be theft by unlawful taking. They actually take the equipment and they hightail it somewhere, and the equipment's never recovered. The situation that we have with theft of service is that one of my members has a piece of equipment out and they're trying to find it, and ultimately they find it and repossess it, but there's a lot of money owed because they've been trying to find that equipment for, as our distinguished sponsor said, they're keeping it 60, 90 days even. But the equipment is recovered, is physically recovered by the rental company. So that is the difference between what I usually call theft by conversion. They actually steal the equipment. Here is what they've done is they've stolen the time, because there's an opportunity cost, obviously, for the rental agency. If they had that equipment in their possession, they could rent it to somebody else and get that money, get those rental fees. So Does that answer your question?
Yes, it does.
Okay.
Thank you. Thank you, Mr.
Go
Chair.
ahead, Ian.
Thank you. Representative Flannery.
Thank you. Under the fact scenario that was described, why is the current statutory scheme not, why would it not cover a prosecution of what you described?
So, to my understanding, currently a county attorney cannot prosecute a theft of service under our current definition for keeping equipment longer. I'll let you also speak to that, Ian.
Yes. So what we've encountered is when you go to the county attorney, they'll say to us, show us in this statute where items held for rental are in this statute. So where basically rental items are excluded from that. And if I could add back to Representative Herron, our association represents small business owners. We've estimated that this theft of service accounts for over $2 million just to small business owners, and that doesn't include large national. These are just independent owner-operators, husband-wife teams. So it really affects the smaller group of business owners that employ people across the entire state, 121 different stores. So it has a large effect on our association, our industry.
To be clear as well, I think it's important to note the relationship between a company and contractors. So our committee sub came about because of the Contractors Association. I think any contractor, any rental company has that good relationship. This would not apply to. I don't think any rental company is going to go after any contractor that they have a good relationship with. What this is meant for is those bad actors that intentionally and willfully rent a piece of equipment and hold it, and the cost that action incurs onto the local business is in the thousands and thousands of dollars. And so all that this bill does is it enables those local business owners, the national companies, the national rental companies to say, hey, we want to be able to recover the time and the amount lost because we could not go out and rent that piece of equipment again. So that's, in essence, all that this bill does, Mr. Chairman.
Representative Bland.
Thank you. So on the theft by unlawful taking, there's no timeline that says you've got to wait 90 days before they could be charged, even if it's a rental, unless it's something in your agreement, in your rental agreement. And when you come together and you sign an agreement, that's a contract, and you don't return it on the time that is in that contract, then you've breached that contract, correct? If you don't return what you agreed, you've breached the contract. So in my thoughts, is that not a civil matter for that breach of that contract? Is there not a way, I know there's a way to recover costs by taking it civilly. So what I see, and I understand and respect what you're trying to accomplish, but what I see happening is we're going to add something that I will respectfully disagree with the county attorney that it's not already covered. I believe it should be already covered under theft of services. But now we're going to charge somebody with a crime, and what's going to happen, we're going to use our criminal courts to collect debts on somebody who didn't pay, that overheld something from their rental agreement. So we're going to use our criminal courts, and I can tell you what will happen. They'll get charged, they'll come in, they'll say, oh, well, if you drop these charges, I'll pay whatever's owned on the rental part, and they'll pay that part, the charges will be dropped. And so, are we going to bog down our criminal systems on something that normally is addressed through civil litigation?
I think to answer that question, I don't see this as a bogging down of the criminal system. I think this would be a very rare occasion. Would that be correct by saying that, in terms of companies that would actually deal with this? What this does is it gives them another tool in their toolbox to be able to reclaim time. And currently, In the current definition of theft of service, they don't have that tool. And so this is not reclaiming, going on the rental agreement and saying we are going to recover that piece of property. They can do that already now. What they cannot do is say we want to get back the time that we lost because we did not have that piece of equipment. Yes, I would say it is probably fairly rare, but it's not rare enough to where we shouldn't do something about it and help out our local businesses.
Representative Burke.
Thank you, Mr. Chair. I hope that my two questions aren't circular, but they are in the same vein of the questions that are going on. My first question is I just want to confirm that this bill is not going to lead to the prosecution of a family that rents a wedding tent and then the truck breaks down and you can't reach them because they're in the mountains. That's not the circumstance that we're talking about.
No, ma'am.
Okay. And then my second question, will the civil liability still exist for the bad actor? So if they are prosecuted criminally and the criminal penalty applies to them, are we going to see a second case arise where consequential damages will be pled in civil court and you'll be essentially having two bites at the apple?
I don't foresee that happening, but if you want to comment on that as well.
I'm not a lawyer, so I really can't comment on that. I don't know what the situation would be there.
Go ahead.
I don't know. You might have something.
No, and I don't think that's our intention at all. I think what we're ultimately looking for is a deterrent. Right now, people know that they can get away with this action. And because they know they can do it, they continue to do it. And I've often used the reference, it's like Blockbuster. You never rewound your videos until you knew that you had to do it. And once they made a situation where you had to do it, you abided by those rules. And that's really what we're ultimately seeking here, is a fair playing field and a deterrent for this to stop. Because once people know that they can't do it, I do believe it will cease.
Thank you.
Representative Maddox.
Thank you, Mr. Chairman. Representative Lockett, would you agree with the premise that by holding on to this equipment longer than the rental agreement, that these individuals are essentially taking the ability of these business owners to earn money? So
Absolutely.
They're taking from them. And while we're not talking about property in the tangible sense, the fact that this service, which, as you've articulated, is not covered in statute, you are taking their ability to put food on the table for their families. You're taking something from them. And, although the ability to pursue civil action, is there, that can be costly as well. So, understanding that we're talking about removing someone's ability to earn income, provide for their families, I think that this is well merited. I'm appreciative.
Yes. Thank you.
So is there any further discussion? Seeing none, is there a motion? There's a motion. Is there a second? There's a second. Would the clerk please call the roll?
Representative Banta,
Yes.
Representative Blanton,
Explain my vote quickly.
Yes, sir.
I have my reservations about the things I talked about, but this is just the first step in the process, so I'm going to vote aye today as we move forward, but I would like to have further discussions. I don't want us using our courts and our law enforcement to be collecting civil penalties.
Representative Bratcher,
Yes.
Representative Bray,
Yes.
Representative Burke,
I'd like to explain my vote.
Yes, you may.
Today I'm going to pass. I share some of the same reservations that have been expressed by the committee, and I'm concerned both about the two bites at the apple possibility and also that we would be creating debtor prisons, which I don't think serves the public. If you need money, we need to get you money, but putting people into prison doesn't get you money. Thank you.
Representative Decker,
Yes.
Representative Dietz,
I'd like to explain my vote.
Yes, you may.
I'm going to vote yes. I have the same concerns that have been expressed. I think using our court system to collect on something that's civil and putting our prosecutors overworking them is a concern. So I'm a yes for today, but would hope that we can work on some of the language.
Representative Doan,
Go ahead.
I'm a yes for today, but if we are going to use our courts to prosecute individuals in this category, I'd like to see us not only protect companies, but to protect individual property owners as well. Thank you.
Representative Flannery,
Explain my vote, please. I want to vote yes, although based on my previous question, I believe the current statutory scheme already allows for prosecution on the fact scenario described, but there's a belief that it's not, then I'll consider voting for it on the floor. Thank you.
Representative Herron,
Pass.
Representative Kulkarni,
Briefly explain, Chairman.
Yes, ma'am.
I'm a pass for today. I'm, of course, sharing the concerns that have been raised here, and I reserve the right to change my vote based on your conversations with Representative Blanton and any based on these discussions that you're going to have. Thank you.
Representative Lewis,
Yes.
Representative Maddox,
Yes.
Representative Mosier, Representative Nemus,
Yes.
Representative Petrie, Representative Rawlings,
Yes.
Representative Sharp,
Aye.
Representative Stevenson.
May I explain my vote?
Yes, you may.
I don't think we can criminalize our way out into a better business proposition. And I'm sure that while you haven't thought about whether or not someone can have 2 bites at the apple, that there will be people that will take 2 bites at the apple. So there are better practices to get people to comply, and they're already in law. So I am a no unless we can deal with this 2 bites at the apple and not only help the business owner, but help the person that's renting the equipment, as someone previously said.
Representative Wilson,
I'd like to explain my vote.
Yes, please.
My vote's a yes. This is not using criminal court to collect debt. It's using prosecution to punish theft. If the charges are dismissed because of a lenient victim and prosecutor, that is not 2 bites at the apple. That is leniency. I'm a yes.
Chair Elliott,
Aye. So with 15 yes votes, 1 no vote, 2 pass votes, House Bill 95 is amended by the substitute is passed and will be reported with favorable expression.
Oh, I'm sorry.
Is there correction? I'm sorry. There's 3 pass votes. So
Thank you, Mr.
15
Chairman.
yes, 1 no, 3 pass. So thank you.
Thank you, Mr. Chairman.
Thank you, Mr. Chairman.
Thank you, member.
Thank you, Mr. Chairman.
Representative Stevenson, would you like to record a vote on House Bill 50? Okay. She votes yes. Thank you. So our next item on the agenda is House Bill 176, sponsored by Representative Flannery, an act relating to compensation of jurors.
Good morning.
Good morning. You may proceed.
Patrick Flannery, State Representative for the 96th District. This bill, we hear this phrase a lot. It's a simple bill. It's a 1-page bill. I guess many of you all may be surprised that the compensation for a person serving on jury duty in district or circuit court is $5 per day. And this bill would change that and increase it to the whopping sum of $25 per day, which may still not be enough for those persons serving on jury duty, but it's obviously would be probably more appreciated than $5 a day.
There's a motion and a second. Is there any discussion? Seeing none, would our clerk... Oh, I'm sorry, Representative Blanton. I knew that. I apologize.
Thank you, Representative Flannery. I like your bill. I want to love your bill. So answer me this. Why can't we go to like a minimum $100 a day.
$100.
Where we can actually pay these people. Plus, we struggle to get people to serve on our juries the way it is. If we would pay them something, we might get people more interested or willing, maybe, to serve on our juries. So if we could get this up and be able to afford, I know that's a issue, the affordability, but if we could get to at least 100, that would make it, I could love it then.
Well, that obviously we'd have to, crunch those numbers to see if that works. That wouldn't offend me, but I guess you're welcome to follow your own bill if you want to take it to $100. And maybe the collective will would be that would be better than $25 per day. So,
Representative Burke.
Thank you. My question is in the similar vein. I'm already a big fan of the bill. I'm grateful that you've proposed this. Will counties or municipalities have the ability to provide additional funding if they are able? Or I'm thinking about incidentals like parking. So there are no free parking spots around the Fayette County courthouses. Could the courts offer a parking token in addition to the payment of $25?
So I believe starting on line number 14, it indicates that nothing should be construed to limit local governments from doing that. So I don't think that would limit that. That is something that has actually been addressed to me, that the cost of parking in Jefferson and Fayette actually exceeds $5. So the person serving as a juror actually loses money. But that, I guess that's something I had not thought about because I've not ever served on jury duty in one of those two counties, obviously. But I mean, it's an important consideration, I believe.
Thank you so much for clarifying that. And I'm grateful for your bill.
Thank you.
Representative Rawlings.
Yes, Rep. Flannery, I'm also grateful for the bill. I heard from our local circuit court judge who has Boone and Gallatin counties, and we highly respect him. He knows about budget concerns and about funding, and he suggested, what about $100 a day after the first 2 days? So if they get 2 days of service in, this would help greatly people that have work and aren't compensated. They have jobs, and that rarely or unusually happens. So, in a case like that, after 2 days is what he suggested. Thank you.
Thank you.
So would our secretary please call the roll?
Representative Banta. Representative Blanton.
Aye.
Polkarni.
Yes.
Representative Lewis.
Yes.
Representative Maddox.
Yes.
Representative Mosier.
Yes.
Representative Nemus.
Yes.
Representative Petrie. Representative Rawlings.
Yes.
Representative Sharp.
Aye.
Representative Stevenson.
Aye.
Representative Wilson. Chair Elliott.
Aye. So with 19 yes votes and no votes, House Bill 176 is passed and will be reported with favorable expression. Congratulations. So our last item on the agenda is House Bill 207, an act relating to crimes and punishments. Representative Dietz. Why don't you do that? And I'm going to yield to my vice chair for an introduction before you all go ahead.
I want to recognize, thank you, Mr. Chairman, and I want to recognize and welcome my district judge from my county, Donna Dutton. She is here today. She's part of the Judiciary Committee of the District Judges Association, and she is a big fan of the bill we just passed, and we welcome you today. Thank you.
Welcome. Welcome. Yes, Representative Burke, you're recognized.
It's my great privilege to honor another guest in our presence today, District Judge Lindsay Hughes Thurston from Fayette County. Thank you for being here, Judge.
Welcome. Thank you for being here. And Representative Moser, you need to record a vote.
Yes, I'd like to record a yes vote on House Bill 95, please.
So recorded. You're recognized, Representative Dietz, to introduce your guests and begin your presentation.
Good morning. Thank you, Mr. Chairman and members of the committee. Stephanie Dietz, representative from the 65th District, and I will let my guests introduce themselves.
Good morning. My name is Jeremy Merle. I am the Deputy Commissioner for the Counter-Exploitation Division within the Attorney General's Department of Criminal Investigation.
Good morning. Mike Bowling, Lieutenant of the State Police. I command the Electronic Crime Branch and the statewide Internet Crimes Against Children Task Force.
Christina Keith. I'm a member of the Board of Directors of Prevent Child Abuse Kentucky.
Mr. Chairman, members of the committee, there is a committee substitute on this bill. So we have House Bill 207 that originally just dealt with child sex dolls, and then we added in the committee sub. So the difference is that has to do with the digitization of child porn, so the AI component.
Motion on the committee sub.
Second.
There's a motion and a second. All those in favor, please say aye. Aye. Those opposed, no, and the sub is adopted, and you may continue. Also want to recognize former Senator Schroeder, who's here, and I know in a different capacity now in the AG's office, but thanks for being here.
House Bill 207 with the committee substitute defines child sex doll. It also defines computer-generated image and digitization. House Bill 207 also makes it illegal to possess, traffic, import, or promote a child sex doll, and goes on to include the above offenses when it involves a digitization that uses an actual minor or minors as the source. I filed this bill last year at the urging of my Commonwealth attorney, Rob Sanders. He could not be with us today, he's in trial, when he received a decision in a case where the Court of Appeals vacated a judgment in the Kenton Circuit Court denying a defendant's motion to suppress evidence. In short, possession of an anatomically correct child sex doll is not illegal in Kentucky and therefore cannot be used as probable cause to search for further child pornography. This year, after talking with the Kentucky State Police, I added language including the digitization or AI component. In your folders today, you have a letter from Dr. Ed Connor. I've known Dr. Ed Connor my entire legal career. He provides the forensic assessment for sex offenders in the northern Kentucky area and I think throughout the state. So I think the fact that he has provided that letter should speak volumes to you. You also find letters of support from other agencies in your folder. And at this time, I will go ahead and turn it over to you.
Good morning again. On behalf of the Attorney General, Russell Coleman, thank you for the opportunity to speak to you today and discuss Representative Dietz's bill. We believe that the legislation she's proposed closes a current loophole in dealing with child sex dolls and then also gives prosecutors and law enforcement officers new tools to deal with a new trend in child sex abuse material. I'm going to speak to the first part of the legislation, which is the child sex doll itself. I want to be very clear when we're talking about these. When law enforcement discovers one of these dolls, there is no question, no gray area of what this type of doll is made for and what it's used for. The scariest part is that scientific evidence proves that people that utilize or abuse these dolls also go on to be hands-on offenders if they haven't done so already. That's why it's important for us to address this type of legislation. At this time, I'm going to turn it over to Lieutenant Mike Bolin, and he can discuss the computer-generated images and digitization.
Thank you very much. And I want to talk to you more from the heart and briefly from my notes on what we see at the Electronic Crime Branch within the State Police and the ICAC Task Force. AI is here, and we see it with a lot of apps and a lot of programs that we use, asking questions, sometimes help with homework, math homework, things like that. And you've noticed some of your universities have already started using programs to say, did this essay or did this thesis come from AI-generated components? Well, with the good, we unfortunately often see the bad, and people take advantage of the new technology that's out there. With AI, people can use text prompts to make an image. They can type in body type, hair color, size, age, whatever you want. You can make it not safe for work, as they call it. You can make it explicit, whatever you want. You can prompt and tell what kind of image to make. Now, with a deep fake, that's slightly different. And I think a deep fake image is extremely, extremely dangerous, because you can take an application or a program on the internet, you can load a picture into it of somebody that you know and create a nude image, what AI would say that person would look like nude. It's called nudifying, or to nudify an image. And the unfortunate thing with this, child sexual abuse material victims, known victims that are categorized by the National Center for Missing and Exploited Children, are now being re-victimized. They're taking those photographs of those babies when they were victimized and making new series, new images with AI using those child's faces, those child's bodies. And with the deep fakes, you have the psychological impact of our school kids. You know, the mental, not only do we need to identify these kids that are these nudifying or these new images are being produced by, but the psychological impact of having their image passed around a school. I mean, I'm a dad, and I cannot imagine my child coming home and me saying, well, I'm the commander of electronic crime branch. Son, I'm sorry, there's nothing I can do. And that kills me to think that. So I think this is a great deterrent toward our citizens, saying we're ahead of it. We're working with technology to get this legislation through. And I think it is a great way to do legal compliance, victim identification, and child victim identification as well. But thank you for your time.
Motion and a second. I'm sure there's discussion. I have a question. Has any other state moved to ban these dolls that you're aware of?
Yes, sir, several. I can provide you with a list.
Okay. Representative Bray.
Just a comment on the AI portion of this. You know, over the summer, spent a lot of time learning about it, and one of my first concerns was on this portion of artificial intelligence and kind of where we're going in the future. We've seen a drastic increase in suicide among children, especially of the high school age, and a lot of that goes back to texting inappropriate images of their self, and then that gets passed around schools. Kids are being blackmailed. Well, this goes even further than that, because now you've got kids who aren't engaged in any of that activity, and they can all become victims. And, I've got 2 small children, and just the fact that even my youngest 6-year-old daughter, she could become a victim of this. This is so needed and so appreciated, because unfortunately we've seen some real sickness, and it's not going to get better. And we've got to make sure you all have the tools to fight this, because we're headed to some uncharted territory, and there's some real scary possibilities on the horizon. So just thank you all.
Thank you. So seeing no other discussion, would our secretary please call the roll?
Representative Banta. Representative Blanton.
Aye.
Representative Bratcher.
Yes.
Representative Bray.
Yes.
Representative Burke.
Yes.
Representative Decker.
Yes.
Representative Dietz.
Yes.
Representative Doan.
Yes.
Representative Flannery.
Yes.
Representative Herron.
Yes.
Representative Kulkarni.
Yes.
Representative Lewis.
Yes.
Representative Maddox.
Yes.
Representative Mosier.
Yes.
Representative Nemus.
Yes.
Representative Petrie. Representative Rawlings.
Yes.
Representative Sharp.
Aye.
Representative Stevenson.
Yes.
Representative Wilson. Chair Elliott.
Aye. $19 yes, no votes. HB 207, as amended by the substitute, is passed and should be reported with favorable expression. Congratulations.
Thank you, and thank you to our guests.
Thank you. There's no other business to come before the committee. We'll stand adjourned.